This meeting of the Littleton Licensing Authority will come to order. Before we begin, I'd like to make the following announcement. All attendees in the room, even if you have cell phones on vibrate or silent, the phone signal will still interfere with the room sound system, so please turn off all cell phones. Rochelle, would you call the roll, please?
Authority Member Bradish.
Present.
Authority Member Gunya. Authority Member Price.
Here.
Authority Member Odell.
Here.
Authority Member Cole.
Here.
Authority Member Forrest.
Here.
Authority Member Mather.
Here.
Next item of business is the minutes of the previous meeting, which we have all been provided a copy of. Are there any modifications to the minutes? Any questions about the minutes? Motion to approve the minutes.
I'll move to approve the minutes.
I'll second.
All in favor?
Aye.
Next item of business, approval of the agenda for this meeting. I'd like to make a motion that we approve the agenda.
I'll second that.
All in favor?
Aye.
Aye. Next item of business, item number 6G, renewal application and probable cause hearing on renewal application for Tavern Littleton Incorporated, doing business as Tavern Littleton, 2589 West Main Street. City Attorney.
Yes, good evening. Tricia McCarthy is appearing tonight for Kirsten Crawford. One moment. Do you want me to just do that, or I don't know. You just present it the way you decide. Okay, tonight this matter comes on with the Tavern Littleton, Inc. at 2589 West Main Street. It comes before the authority on a probable cause hearing. The background is that this application is being referred to the authority because of an August 12th investigation report submitted by Littleton Police Sergeant Kim Ferber, now Lieutenant Ferber, detailing several incidences. I believe the board has a copy of all the various police reports.
We do.
For their perusal. These incidents have occurred in the last several months, from approximately June 24th is the first incident to the last incident on August 12th. Staff believes that this investigation report should be submitted to the authority because this establishment has failed to operate responsibly. When looking at all of the incidents as a whole, we believe that there is a violation of the Colorado Liquor Code 1247-901-1A entitled Unlawful Acts, and Colorado Liquor Code Regulation 47900, Conduct of an Establishment. And we present this tonight to you for your review on the probable cause issue.
I have a question for the city attorney, for the city, actually. These events that we read about in the police reports and so forth were taking place in July and August. We haven't had any action taken against this licensee in that time, even though there were obviously some potential liquor violations. Why is that?
That is a question I may defer to the police department, because those matters were handled, each and every one, by the police department.
Would you like to step up to the microphone, Kim?
Obviously, the Littleton Police Department investigates each of these matters individually, and I review the reports that come up into the Investigations Division on a daily basis. And when I receive a renewal notice, then I compile any reports that we have had at those establishments and forward those to the city's attorney's office for review. In circumstances where we have not found probable cause, at least at the scene, to cite somebody, the manager, the owner, or somebody who's employed by the establishment, then we don't forward necessarily those reports at that time to the city attorney's office until there has been a violation. And that was the circumstances in this case specifically under case 4110, where we had cited the manager of the establishment. Then that is when the city attorney's office decided that we would bring these matters forward. So I will say that we have a lot of businesses, as you know, in the city, and we take incident reports at all of those businesses on a regular basis, and they are not forwarded to you unless there's a violation.
In retrospect, do you wish you would have brought up a liquor citation for any of these things so that we would have had them in here for a hearing before there was such a large number?
This
of
isn't
offenses?
necessarily inconsistent with what we see in other establishments in the city, and some of them at least. And when there is a violation, then we do forward those through. Our policy at the police department is that we require officers to make a report, whether there's a violation or not, just because we want to be aware of what's happening in those establishments.
Sure.
But that doesn't necessarily mean there's a violation. Does that make sense?
Yeah, I guess I don't really understand how you get from the police report to a liquor violation. Maybe that's what I need to have explained to me.
Especially looking at 3893.
I thought they sort of came together at the same time. But
I guess I have one big question. When someone comes in on a probable cause and the liquor license is still in effect, there's a whole range of penalties we can look at.
Sure.
When we look at this here, is the only thing we can do refuse to renew the license? I mean, if some of these had been brought up, like, especially I'm concerned about the one on July 31st, where it was determined that someone was under 21 and had been drinking alcoholic beverages.
Yeah, and that's a situation where the command staff actually of the Littleton Police Department has met with the staff and the owner of the tavern, and have been putting some systems in place to address some of these problems, because they are new in our jurisdiction, and we identified the problem and wanted to address some of those. And if you feel it's appropriate that you get some of this information ahead of time when there's not an actual violation that's cited in the field, that's something that you would have to make that decision. That I don't believe that's mine to be made.
And part of the reason you wouldn't have gotten them right away would be, if I remember correctly, some of them were still under investigation. They hadn't been completed to be a report to come to us. And June 24th is the first one, and this renewal report fell right in the middle of when all of these incidents were happening. So rather than send them to the board as individual incidents, they were sent as a collective thing as part of the renewal, because they were happening and they were not complete when the renewal was sitting there waiting to go through and be approved pending police department background on these reports, and the reports came in during that period. So they wouldn't have come to you before that, because I believe they only opened in May. The restaurant opened in May.
Yeah, I don't know the opening date, but
they turned in their renewal before they opened. So it was in the renewal process when all these reports came in. So it was done as part of the renewal rather than individually.
My question is, as a matter of process, which of the police reports corresponds to what specific liquor violation, or are we looking at the totality and that corresponds to a liquor violation? I guess that's my question.
I would respond that we're looking at the totality. All fall under the conduct of an establishment.
They've had their liquor license for a year. right? Is that correct? But they've only been open for 3 months?
Correct.
They got their license approved before the construction was finished on the building. They wanted to make sure they had a license before they spent the money to finish out the building. I remember that. And that's done all the time.
Yeah, I know that.
And the expiration date, just for the record, is July 13th of this year. So it did kind of fall right in the middle of
The expiration date of their license?
of their license.
So they're operate, I mean, how does that work? They've got a couple months for
As
you-
long as they turn in their renewal before it expires, it goes into a hold pattern pending renewal or non-renewal.
Yeah.
So it just stays there. Sometimes it'll be months before it gets done, but they've turned it in prior to the expiration date, so the state law says if you've turned it in on time, it just kind of sits there and goes into a hold pattern until it's either renewed or non-renewed or denied.
I have a question connected this conversation with the incident on August the 12th. As a result of that incident, a summons was issued for the sale of alcohol to an intoxicated person to the tavern manager, Mr. Pritchard. He was to appear in court on September the 14th that morning. Of course, we have no way of knowing if that proceeding was delayed for some reason or if it actually took place and there was a verdict rendered. My question is, if a citation by Littleton Police Department was issued to the manager of the tavern for selling to an intoxicated person, does that potentially come before this authority also for our decision, independent that of the courts, as to whether he sold to an intoxicated person so that we can render a judgment as to suspension of the license or it not being reissued?
I would respond to that. It does come before you like any other violation would. For example, sale to a minor in some of the stings that we conduct, that particular liquor store owner or the liquor store employee will oftentimes get a ticket that's written into the municipal court that they will have to handle. In addition, the establishment gets summons before the liquor authority.
So I realize in this instance the manager does not come under the preview of the licensing authority. That is a matter for I guess it's a criminal court rather than civil. But as to the licensing, if that's been issued, I should imagine it should appear before the authority, and that was in September, regardless of the verdict issued by the municipal court.
That is correct, and I can tell you I am familiar with that case. That case did get continued, and we're going to hear it in municipal court next week. And that will go on its own course. And then the larger issue of the licensee comes before the liquor authority, and it can specifically deal with the facts that occurred in that particular incident.
Thank you.
I think clearly, based on what you've presented us, there's probable cause for hearing on the renewal application. I guess what we were just asking is how many citations do there have to be before you guys bring it to us? Do you know what I mean? That seems like an awful lot. And I know it happened in the interim during the period of time, but good heavens, from June to August, that's a lot.
And I think, as Lieutenant Ferber explained, there was really only one citation that was issued, and that was the last one, report 4110. The other cases there were no citations that were issued on scene. I think one of them is still pending. Is that correct? The 3893?
Yes. Also, there's that felony investigation.
Which is this one. The last two, the one from July 31st, 3893, and August 5th, 3979, those are both still pending investigations. And all the other incidences, which appears to be 4, no citations were issued, at least for the establishment.
So if I understand what we're focusing on for tonight, reading the legal opinion, is that we're supposed to be focusing on whether this evidence establishes good cause, really just that there's been disorderly conduct, and that there has been no adjudication or final finding that there was sale to a minor or other liquor code violations. Those might come sometime in the future, but for purposes of what we're reviewing tonight, it's just that perhaps more general question of whether the totality of these issues constitutes disorderly conduct.
That's correct.
The whole purpose tonight is to determine whether they need to come in and show cause why their license should be renewed at next month's meeting. And we're not going to argue facts. We're not going to talk about the whether they actually did it or not. We're only going to decide whether we need to have them come in here publicly and explain their situation.
That's correct. If you look at all the facts and evidence and believe that it's more probable than not that something happened, and they should come in and answer for it.
In that regard, I'd like to ask our police officer, in investigation of establishments that sell alcohol, how typical is it in these investigations for you to find this many violations within this short a period of time?
I would say it's not that common for something like this to occur in the city of Littleton. This establishment has been working hard with the city of Littleton or the police department to try to put some guidelines together to sort of minimize these things. I don't think that they realized that they would draw the crowd that they did draw. And so while this seems like there were quite a few, and it has declined since then, and we don't normally see this in our other establishments. Not this volume.
Okay, thank you.
Yes, I'm just wondering if we have to do it as the all or nothing with the renewal. Do you know what I mean? I mean, is it possible that, and maybe we can just talk about this at the, probable cause is a different thing. It just seems like, if we find disorderly conduct, we won't be renewing the license.
And just for clarification, too, the disorderly conduct in the legal opinion, that's given as an aid to define it. Really what we're looking for is conduct of an establishment and whether or not that fits under the state law. In answering your question, Councilmember Price, I believe that you guys can find a couple of different avenues. You can determine in the future that the license should not be renewed. You can determine that the license should be renewed, and you can determine that the license should be renewed with conditions.
What was that last part again?
With conditions.
With conditions.
Now, is there a fourth option that we would provide some sort of penalty like we would if you were in the middle of your license? We would renew it, but say,
Suspend it or something.
yeah, suspend. I mean, is that an option or?
That's kind of what I'm referring to as the third option.
Okay.
So we could renew it with a suspension.
But would they be prepared to argue that if we have a show cause hearing only on the issue of renewing the application?
Well, their attorney is present tonight, so I hope he will be prepared to argue any of those scenarios.
I understand that we have a very narrow issue in front of us today. I just don't want to have, two hearings in the future. But
I'm kind of interested in the letter that Frank Schultz sent to Heather Coogan, dated Thursday, August 25th. And in this letter, he mentioned that they hadn't expected quite the reaction that they would get to this new opening, and they got more people than they had anticipated. And it's a new establishment, and as I understand it, the taverns are very popular throughout the Denver metro area. So it said he was going to take some steps to help, alleviate the problems that they're having with the dress code, change the format of the music. The drink specials are being limited. ID monitoring. He's talking about buying some scanners because, as I understand it, the fake IDs anymore are very sophisticated. And I know when they look at my ID at a bar, they just glance at it. But if I were a little closer to 20 or 21, you know, I might have something that could pass. So I think these scanners are a very good idea. So I'd like to know what they have put in place. You know, we got kind of an overall here.
And let me interrupt you just for a second. The information in that letter and the processes that they intend to go through, perfect discussion to be held in the actual show cause hearing.
Oh, okay.
And I think that letter is a good reason to have the hearing.
Right.
Because they will have an opportunity to present all of the actions they've taken and all the actions they plan to take and influence us with that argument.
Can we?
It's not going to happen tonight, though,
Okay.
and I know the attorney is not going to argue the facts or argue against not renewing the license, because that'll be at the next meeting.
Will they be able to tell us when they implemented these changes and if there's been any
Sure, you
any
They'll
violations
be
since
able
then?
to present their case as fully and as completely as
Yep.
they want to. And the city will have an opportunity to present the other side of it. And then it'll be up to us to make a decision. But tonight's not that decision.
So I guess my only question is, can we have the show cause hearing and make clear that the fourth option, I think you said,
The third.
renew with
Renew with.
conditions, since the attorney is here, I would like everybody to have notice that it's not just going to be on the renewal, but it could be as Andrew.
Renewal with conditions.
Yeah.
I agree with that, and that was one of the questions I came here with today, was to ask you, do we go up or down on the license renewal, or we do other options? Obviously, we have other options.
Yes, I don't believe this is an all or nothing type situation. I think the code does provide for you to have some leeway and grant that renewal with some conditions, some sanctions, whatever the board thinks is appropriate.
I believe the authority, if, as I'm going to make the presumption before the vote that this hearing will occur, if it does in fact occur, I think authority members would be very appreciative at the outset that the city attorney's office does outline the options for the authority members, so that we, as we listen to everything, we know what direction we may or may not be headed.
Sure.
Thank you.
Along the same line, I think it would be helpful, if we're looking into November, to have an additional report from law enforcement about what additional incidents have occurred since that time, because I think that'll be appropriate for potentially for us to consider, at least under a mitigation standard, which I think is one of the elements of determining whether you're going to suspend a license, is mitigating activities by the licensor.
Well, clearly the license holder is going to have notice of that as well. So, I mean, it can't just be, I mean, if there are new incidents, everybody's going to have notice. Or if there are no new incidents, everybody's going to have notice.
Sir, Mr. Attorney, did you intend to speak knowing what the purpose of this hearing is and hearing my remarks? Would you still like to speak with us? You're welcome to if you do.
Well, I believe the procedures is we're not allowed to speak
Yeah,
at a show cause.
that's-
But I did not know that this was a non-renewal till possible until tonight. The original notice I got was a show cause. And I really don't think there's any prohibition against renewing a license. You could revoke it the next day. But to have that non-renewal, that's really unusual to me that we'd have I mean, we're in for a show cause on a renewed license, and you guys could suspend it, you could revoke it. You know, your options are there. It doesn't change if the license is renewed. I've never come across a situation like this where the license was in limbo, and that would be, a non-renewal would be the equivalent of revocation on a first offense, and I think that would be pretty unprecedented.
Well, and that's exactly what we were saying, is we don't want to have to have only the renewal or the
No,
revocation.
and I didn't know it was on the table until tonight, and that's pretty scary. But I think we've got great mitigation. I don't anticipate that, but it is.
So you understand that if we're arguing that at the next hearing, we may be, if it's not revocation, it may be some kind of penalty? Or
Yeah, that's what I would
condition or
expect. I
Okay.
mean, somebody, you know,
So we're not going to have any problem with,
if we
no,
can't
we thought it was
convince
only.
you on our mitigation that this, you know, that
Right.
if there's a penalty, there's a penalty, but a non-renewal would be, especially in light of all the steps. They really have done some great things, but I don't want to, that's not for tonight. But that would be a pretty radical outcome. I'd be in pretty bad shape then. But anyway, I don't think, it's not a really, I think the rules are that we're, you know, we understand what's, and we'll talk with the city attorney and the clerk between now and then about that non-renewal issue.
We understand that there are things you're able to do between now and a month from now also to work with the city, and you will do that, and we'll be ready to talk to you again in a month.
I'll bet you we'll be ready to go.
Thank you, sir.
Thanks a lot.
Any discussion among the board members?
No, given the fact that everybody agrees that it's not going to be an all or nothing on this revocation or non-renewal, or that we would treat it as a license that maybe was renewed, and then we'd be talking about the kind of penalties we've talked about in the past, like, you know, suspension and things like that. I'm fine with it.
Well, that's one of the reasons I want a great deal of clarity from the city attorney's office, because the violations that we were presented under the Colorado Liquor Code, I'm not able to determine if those are specifically what we're looking at, what is allowed under those statutes as for of how we proceed. We may not, under statute, be able to proceed in a direction we might want to go. I don't assume that's the case, but I don't know, and what I need clarity is because this statute, in the Colorado Liquor Code, I don't know if it says our only alternative is to renew or not renew. And then if we've not established that there is any violation of the liquor code per se where we would say go ahead and consider suspending the license, if there's no violation there, because the police department to this point in time said they were not comfortable with coming and presenting anything to the authority as a violation, if there's no violation, I think there has to be a discussion as to whether this establishment is out of bounds or not under the code. So,
Well, clearly, on the August 12th incident, the police have found that there was at least a potential violation of
there was a potential. We don't know. That's why I was asking. We do not know the results out of the Littleton Municipal Court, what the findings were, and despite those findings, it may be, since that is a matter of, I'm not sure, civil or criminal law, what would come before us is an entirely different matter for us to establish if there had been a violation in order to suspend that license, and may be influenced, but wouldn't necessarily be determined by the findings of the Littleton Municipal Court.
Well, right. I mean, when the stings take place, we don't wait for the criminal. I mean, we take action based on the facts that we have. So, I mean, I don't know that.
And there really are different standards.
Yes,
And
that's what I'm
different
saying,
law,
and we need to make that determination here, for example, on August 12th, what it is, what we have in a police report and is being presented is that a manager was issued a violation for serving someone already intoxicated. Based on that or whatever other evidence, it would then be the authority to determine if they felt that indeed that violation had occurred and what action they wanted to take against the tavern on that specific incident. But these are all being rolled up into run. This is something obviously new for the authority to look at, and I just want to be crystal clear personally, and think the other board members would be more at ease if we felt we were on a real sure footing as to what the law was and was not in regard to these incidences and again, what courses under our authority we had that were available for us to pursue.
Well, that seems to be a couple different questions. The first question appears to be what law would enable you, what law you would use to apply to the facts. And that's what we had talked about earlier, the Colorado Liquor Code 1247-901, unlawful acts to sell, serve, give away, dispose of, exchange, or to deliver or permit the sale, serving, giving, or procuring of any alcoholic beverage to a visibly intoxicated person or to a known habitual drunkard. And Colorado Liquor Code violation 47-900, conduct of an establishment. Orderliness, loitering, serving of intoxicated person. Each person licensed under Article 46, 47, and 48 of Title 12, and any employee or agent of such licensee shall conduct the licensed premises in a decent, orderly, respectable manner, shall not permit on the licensed premises the serving or loitering of visibly intoxicated persons or habitual drunkard, nor shall the licensee, his employee, or agent knowingly permit any activity or acts of disorderly conduct as defined and provided for in Section 18.9.106 CRS. Nor shall any licensee permit rowdiness, undue noise, or other disturbances or activity offensive to the senses of the average citizen or to the residents of the neighborhood in which the licensed establishment is located. So as the facts are concerned and your determination tonight as to probable cause, that is the law that you would look to in reviewing the facts to determine whether probable cause exists. As to the license renewal, CRS 1247-3021 gives the licensing authority the power to look at the renewal, gives them the power to refuse to renew a license, and for good cause, basically.
So let me just clear up. My understanding from the police is that, I mean, it seems to me like the August 12th incident would have made its way to us regardless of a renewal. But because a renewal had come up and there were some other incidents and you would put it all together, that's why it's not before us until now, although I guess this would have been the first. But that's the position, right? It's not that we didn't get this until other things happened, right? I mean, it was just a matter of timing. Okay. So, yeah, I mean, it seems to me pretty obvious that the August 12th incident at least would be a reason to have a show cause hearing.
But I guess, you know, the suggested motion that we find that there's probable cause, a good cause exists to deny renewal of the license. I'd just like to make clear that it's either to deny or to approve renewal, but
Conditions.
Hearing will be held on the issue of conditions, or I don't exactly know how to word it, I think.
Well,
So
I think the motion just, it sets up the, there is good cause to deny the renewal. It doesn't say we have to deny the renewal, but there is good cause, and I believe there is, to deny the renewal if that's what we decided. But
The heart of the
have another hearing on the issue of some kind of penalty.
No.
So I think the motion needs to be that there's going to be a show cause hearing on both issues. You know, either the renewal of the license and or penalty for violation of CRS 1247-901.
I think the heart of what tonight is to determine whether there's probable cause.
that's what I say.
Well,
That's the heart.
Yeah,
And
probable
that
cause.
part of the motion, I don't think is what the heart is. I think under the law at the next hearing, you will have all the remedies available, just as if this was an independent action brought during the course of the license.
Well,
It's
yeah,
different issues.
But I understand Susan's concern, and she doesn't want to come in and have us decide we're not going to deny renewal, but now we got to have another hearing on these other matters. I
feel
want
a
to take
little
care of
more
everything
comfortable.
in one meeting.
Since the attorney's here, and he's indicated that he's okay with us having a hearing on the issue of penalties with renewal of the license.
I see no, I mean, just based on my experience, I don't think this would rise to the common rule. I think certainly it's within the authority set a show cause, but because if it's aggravated enough, you can revoke at a later time. I don't see any reason not to renew the license.
We understand that.
Well, it's licenses get renewed all the time with pending violations, and if they're bad enough, a license can be revoked or suspended. But it's quite unusual to have a caption this way.
Well, it's also quite unusual for someone to have a license starting in May and have this many incidents. So, I mean, I understand what you're saying. I just want to make sure that you don't show up at the next hearing and say, okay, we're here only on the issue of renewal of the license, and if you want to find that there's some kind of violation of the liquor code and impose some kind of other sanction, we're not prepared to argue that today.
So,
Well, we have the authority to make that decision.
Well, not if we only...
well, could I propose some language? I would propose, and I guess the attorney can tell me if it's, city attorney can tell me if this would trip us up, but instead to make a motion, I would propose that we would make a motion. I move that the licensing authority find there is probable cause that good cause exists to consider the status of the license of Tavern Littleton. And that, I would think, would provide us the ability to go into next week, next month, have a show cause hearing.
I agree. I don't think your hands are going to be tied, and we're clearly on notice.
So would that prevent us from, give us any trouble with what we need to do next month?
I don't believe it does.
Okay.
I think it's fine.
Is the applicant's counsel satisfied that he has enough advance notice to understand what's going to happen at the next hearing?
I do.
From a due process perspective?
I didn't until tonight know that the renewal was on the table, but I do now.
Thank you.
I think the other thing to keep in mind, and it's been brought up several times, is the issue regarding the police department and whether or not anything's been brought forth in the earlier cases. Lieutenant Ferber was talking about charges into the court on the earlier cases. Please understand that that's a different standard, bringing things into municipal court than bringing them here. And it sounds as if that's the police department standard, that if there aren't charges brought forth to municipal court, that is what triggers bringing it in front of the licensing authority.
So even if there's 10 incidents that may not rise to criminal charges being filed, the police department won't be bringing it to anybody on the Liquor Commission's notice?
It would be part of the renewal report, and it would be happening exactly as it's
What
happening.
if it's not until, what if it happens in March or April?
That's when it would happen then, was when the renewal came up. If all of those things were a collective thing that the attorney's office felt needs to go before the board, that's when it would be addressed, if the police department didn't bring it before then.
So in the, I guess to move things along, I'm going to make a motion on the probable cause, and then I think if we want to maybe continue a discussion about procedure. So I move that the licensing...
The wording, how
So-
you think it should read.
Okay, so I move that the licensing authority find there is probable cause that good cause exists to consider the status of the license for Tavern Littleton, Inc., DBA Tavern Littleton, 2589 West Main Street. Based on said findings, I move a public hearing be set for the 9th day of November 2011 for the purpose of considering the status of said hotel and restaurant liquor license, wherein the above-mentioned licensee may be present to show cause, if any, why its license should not be revoked, and further that notice of these findings in the hearing to show cause shall be forwarded and served to Tavern Littleton, Inc., DBA Tavern Littleton, in accordance with the provisions of state law.
I second the motion. We have a discussion on the motion. Rochelle, would you poll the authority, please?
Authority Member Bradish?
Yes.
Authority Member Price?
Yes.
Authority Member Odell?
Yes.
Authority Member Cole?
Yes.
Authority Member Forrest?
Yes.
Motion carried. We'll see you November 9th, sir.
So I didn't mean to cut off any discussion about procedure. I just wanted to tie it all off.
I think the wording of that motion covers it. The agenda has no other items for this evening other than reports. Do we have any reports from the staff?
Nope.
Authority members?
Do we have any ballpark figure when the authority is going to come together and the city attorney's office will instruct us about the what city council's passed as far as fining on for a first offense?
Well, they already passed the ordinance and the resolution on that, but due to changes in the city attorney's office that have happened lately, Kirsten is the only person here. She just simply doesn't have time to do it right now. So Bill and I talked about it and also talked to Kirsten about it, and it's put off right now. They're not in the process of doing any stings that I know of, and that would really be the only incident that you'd probably be using that. So it's just kind of put off until she has more time to do it, because the rules and procedures have to be completely rewritten to incorporate that procedure into it. So it's going to take a little bit of time. So
I anticipated it, but thank you.
You know, it's not really a high priority item for us anyway.
right.
Chairperson has no other items, so the meeting is adjourned.